My name is Nick Camiotti, principal at Bressler, Amory & Ross in the firm's financial institutions and cannabis practices. And we thought it would be a good time to talk about the business of cannabis as this industry grows into one of the larger industries in the country, and based on all of the news that you see, it's only going to continue to grow. We wanted to give people a little bit of level setting of some of the challenges that are in this unique space and some of the ways that you can be involved, or you can protect yourself if you're in the business already, and some of the issues that you may deal with, whether you're in the industry or dealing with an ancillary service provider, or just happen to do business with one of these entities. There's a lot of different ways which people and companies become have to deal with the cannabis industry, and there's some unique challenges there and a lot of unique opportunities as well. So we have a great panel today. We have first, we're going to talk about some of the primary needs that an emerging business in any space needs, and that's to protect your intellectual property. And Jessica Gonzalez is going to talk about that. Jessica is attorney at Bressler, Amory & Ross. She is in our cannabis group and runs our trademark group. She's also the general counsel for minorities for medical marijuana. We have Brian Ellis as well. He's counsel at Bressler, Amory & Ross. He's in the firm's cannabis and financial institutions practice. And then we have Dan Rhoda, who's the co-founder and CEO of Abaca Bank out of Little Rock, Arkansas. And Dan provides financial solutions for companies that are in the cannabis space. And when we talk about cannabis, obviously that's a newish term, I'll just say, but you have your what's your medical marijuana or adult use marijuana, and then you also have your hemp or CBD companies, and that's something that people obviously should be aware that there is a difference between the two. But the fact that you have now with the Farm Bill, you have hemp legal pursuant to that act, pursuant to whatever regulations are in place in the states that that your business is, versus marijuana, which is state by state, federally illegal, Schedule I narcotic. But because of this unique dichotomy where we have certain state legalization, certain federal legalization, certain federal prohibition, it lends itself to unique challenges that companies both in the industry and who do business with the industry have to deal with. Our last presenter is David Gonzalez, who's managing member and general counsel of Yorkville Advisors Global. He's having an issue getting in to here, but he will be on any second. So we're going. The good news is David was supposed to go last. So with that, we'll turn it over to Jessica, and we'll see if I can help get David up on the screen so that we can get the full crew ready to go. On the bottom, there's a chat feature. If you have questions, you can put in a question and we'll try to get to it. We do have a lot of material. We'll do our best to answer it if you have a question. And with that, I'll turn it over to Jessica, who's going to talk about intellectual property. Thank you, Jess.
Yep, sure. Awesome. So hi, everyone. So today I'm going to focus specifically on one aspect of intellectual property, and that is trademark law, because it seems to be what's most confusing to a lot of cannabis or hemp owners out there. So if you have a cannabis or hemp company, then you own at the very least one trademark, and you may not have been aware of that, or you may have gotten some pretty wrong advice that just because you own a cannabis or hemp company, or you have cannabis, hemp, weed, pot in your company name or your brand name, that you're unable to acquire federal trademark protection. And I'm here to dispel that myth and to let you know that that is not true. So just by way of background, and for anybody who's not familiar, a trademark is word, name, symbol, device that's used either by a person or an entity to indicate the source of the goods. It basically acts as an informational shortcut for the consumer. So think about the Nike swoosh, think about the McDonald's golden arches, think about the Apple. Those are essentially trademarks. So with cannabis, and for the purpose of this talk, when I talk about cannabis, I'm going to talk about what's above 0.3% THC. When I talk about hemp, 0.3% or lower of THC. So given the federal illegality of cannabis, most cannabis or hemp owners wrongfully assume that they're unable to acquire trademark rights. So the USPTO, the United States Patent and Trademark Office, who's the governing body for all trademarks in the US, they are a federal agency. So they have to adhere to federal laws, which creates a lot of disruption in the trademark space because, as you can see in this map, we have over half of the country has gone green and has rolled back a lot of cannabis prohibitionist laws. So how do you protect your trademark when it's federally illegal and the USPTO is a federal agency, but you are using your trademark in commerce? So just what I want everybody to be aware of is to have a trademark, and it consists of two things. It has to be sold, it has to be used in interstate commerce. And as you know, you cannot ship your cannabis from one state to another, but for trademark purposes, that's one of the requirements. And two, that it has to be distinct and that it has to be unique. The ethos of trademark law is to avoid any confusion in the marketplace as to who is the source or the producer of those goods. So just keep that in mind as I have this conversation. So as you can see, as of right now, this was about June 17th, so there may be more, but there's close to 10,000 live marks that are both either registered or applied for on the USPTO that contain hemp, CBD, or cannabidiol. This is a very big number because in a few minutes, I'm going to show you a timeline of what it looks like and how this has grown incrementally. For cannabis, we have close to 5,000. I'm pretty sure it's probably close to around 5,500 at the moment. And 1,332 registered marks with cannabis, marijuana, or the other spelling of marijuana. Why this is important is because a lot of folks ask me, when do I file my trademark application? So the answer is you should file your trademark application yesterday or a month ago. Try to get it in as soon as you possibly can. 7,000 trademarks are filed on a weekly basis. So if you do have a very unique name, it's something that you're investing a lot of time and resources and energy into, you want to make sure that you get this in as soon as possible because, as you can see, these numbers grow every single day. And here is just a list of the applicable federal laws and federal agencies that the United States Patent and Trademark Office uses to assess cannabis and hemp trademarks. So we have the Agricultural Marketing Act that was amended by the Farm Bill, the Federal Food, Drug, and Cosmetics Act, the Controlled Substance Act. We also have here the Department of Agriculture, the U.S. Department of Human Services, and the Department of Justice, of course, with the DEA. So as you can see, the USPTO has to make sure that all of their guidance is in line with all of these federal agencies and federal laws, which makes trademarking your cannabis, hemp, or CBD good or service a very nuanced process that does require a lot of thought into it, but also a lot of compliance and oversight. So I do not recommend that anybody try to go about this on your own, but I do recommend that you seek out an attorney who is well versed in these areas of law. That way, when you file a trademark, you're not just losing your money. So kind of a quick overview of the USPTO's history with cannabis. So what's very interesting is in 1931, the first cannabis trademark was registered in connection with a cannabis extract. It was renewed in 1991, but unfortunately it is currently expired because they did not renew it. I wish it would still be alive today, but it's not. And then between 1931 and 2009, you only had 200 applications. So just remember in a couple of slides that we have now close to probably around 20,000 between cannabis and hemp. Then the USPTO actually did something April 1st, 2020, they actually created an entry for processed plant matter or for medicinal purposes, namely medical marijuana. Then from April to November, they received over 100 applications for cannabis. And then in July, they removed the entry and they called it a mistake. And then a couple months later, they actually revised the trademark regulations to explicitly mention cannabis and the illegality and why they will not register for it. So it's a bit of a flip-flop that the USPTO has done, but it also shows us that they are kind of willing to move forward with this, but at least until federal prohibition is lifted, we're really not going to see that. But hemp. So once the Farm Bill passed December of 2018, the USPTO a couple months later offered guidance that, hey, we are now accepting applications for hemp and hemp-derived goods and services. However, there are exclusions to it. Once again, because the USPTO is a federal agency, they have to adhere to federal. So the FDA has said CBD beverages, CBD pet products, CBD food, and CBD nutritional supplements are a no-go. So the USPTO has taken the same exact course of action. So if you do have CBD beverages, food, pet products, or nutritional supplements, unfortunately the USPTO will not issue registration for it. However, there are acceptable hemp and hemp-derived goods. Topicals, personal use products, retail stores, ancillary services such as banking, accounting, lawyers, tax, and hemp flower as well. So just keep that in mind that even though, yes, hemp is legal in the country, there are still some facets, some goods that are still not able to require federal trademark protection. And here is just a common issue. So if you want to take this on yourself, which I really don't recommend, you may have some issues with it. There are a lot of refusals that the USPTO is sending out. They're asking a lot of questions. A lot of attorneys are actually questioning whether or not they have the authority to ask some of these inquiries. But these are just some of the common issues. You're applying for goods contrary to FDA guidelines. So you're applying for food, beverages, prep products, dietary supplements. That's going to be an immediate rejection. It's in an inappropriate class as well. So you have to make sure that it's an appropriate class. If you're looking to file for nutritional supplement and pharmaceuticals, you are claiming that it has a medicinal benefit. FDA has said you can't claim that it has any medicinal benefit, automatic rejection.
Just real quick on the class thing, isn't another issue that we get there where people go too broad with the number of classes? Is that another issue? Like with that's not so much of an issue. It's just making sure that it's an appropriate one, right? So for hemp, but for a lot of topicals, you're looking at class 3, which is non-medicinal cosmetics or topicals. Class 5 is for pharmaceuticals, and that's unfortunately where a lot of people tend to file their goods in. But by doing that, you're inadvertently saying it's a pharmaceutical, it has medicinal value. And so the USPTO has taken the approach, can't do that. That was the issue that I know that we've had come up for some people who've come to us, that's all.
Yep, correct.
Thanks, Jess. Sorry for interrupting.
No worries at all. No statement of where the CBD is derived from. CBD can be derived both from the cannabis and the hemp plant. So you need to make sure that you actually specifically state that it is derived from the hemp plant. Common issues, the FDA, up and down, we're not really sure. And so it is going to be a little wonky in that. So keeping apprised of what the FDA is up to. No certificate of analysis as well. So the examiners will ask for the certificate of analysis. So make sure that if you are filing for this, that you do have one at the ready to make sure that you can confirm that your THC levels are at 0.3% or below. And additionally, if you have a first date of use prior to December 20th, 2018, December 20th, 2018 is when the Farm Bill went into effect. So if you placed your date of first use prior to that, that means that it was illegal in state commerce, so you're going to have to revise it. So these are just a couple of the issues to watch out for. Now with cannabis itself, since plant touching, still Schedule 1 drug, you're not going to be able to get a trademark registration for your plant touching goods or services. So by that, I mean your edibles, your cannabis tinctures, your cultivation, your processing services, you can't. So what you have to do is You got to get a little bit more broad. You have to get creative. Look at the other services or goods that your company is selling that you could acquire trademark protection for. Do you have a website where you're providing education? Most likely you're selling your goods on that. You can get a trademark for that. Are you consulting on the side? Do you have apparel, merchandise? Do you have a mobile app? These are all of the different types of goods that you can acquire federal trademark protection for. And that will allow you to, have at least something, because the whole purpose is start your trademark portfolio early, because the moment federal prohibition is lifted, you're going to now have, let's say, 4 trademark registrations, and you're just going to be able to quickly go to USPTO and say, okay, now I want one for my cannabis goods and services. It's going to be that much easier for you to have one because you already have a presence available. And kind of the last slide that I want to just touch on is here's a couple of trademark hemp cannabis trademark litigations that are currently going on. Charlotte's Web is probably one of the most well-known ones, that they are trying to trademark Charlotte's Web. However, one of the companies that's going against them is saying, well, that's actually a very well-known strain name and therefore cannot act as a trademark, because remember what I said in the beginning, it has to be unique, distinctive. But if everybody can use Charlotte's Web as a strain, then it's no longer acting as a unique source identifier. So that's still pending. Rock Harvest and Kiva brands, these two are interesting because in both the courts have sided with state trademarks as having priority over federal trademarks. That does not occur anywhere else. So if you are a cannabis company, plant touching, or if you have clients that are, I would highly encourage state trademarks in light of these two decisions that have come down recently, where courts have sided more with, you have a state trademark, that takes precedent. And the last one that I wanted to show is the Mondelez Canada versus Stony Patch. And the reason I wanted to show it is because there's a lot of punny marks out there that folks are using, and people think that it's funny and that nobody's going to catch on, or the companies are going to think it's hilarious. It's not. The companies are going to consider that trademark dilution. They will go after you, no matter how small you are. So please stay away from any punny marks. Make sure that, once again, it's distinctive, it's unique, and that you're actually able to use it. So kind of to wrap up my chat, make sure you get adequate counsel when it comes to trademarking it. Don't believe anybody who tells you that you can't get a trademark for it. That's absolutely false. Stay away from punny marks, and feel free to reach out to me if you have any questions.
You mean don't just copy candy that's been out for 50 years and change it to something, stony?
No, yeah, and we've seen it. Some folks have like the Coca-Cola, and they've changed it to cannabis, and in the exact same writing, and they sell T-shirts. The same thing with Dare as well. You may have seen that. Yep. Just stay away from that.
Right. Try to be unique. Try to be original. Just copying things that are already in existence and turning it into, hemp or otherwise is just not going to be something that goes very well for you. Thank you, Jessica. That was incredibly succinct, and 20 minutes. I don't think we've ever had somebody hit it so perfect within the allotted time before through the entire Bressler webinar series. CLE code 1, I decided to be easy today, so we're going to do CBD. Will be CLE code 1. I bet you there's some people who could probably figure out what CLE code 2 is. With that, we're going to turn from the intellectual property trademark discussion over to the financial institutions discussion, and this is going to be the 4 of us who are left. But first, we're going to start with Dan and Brian, who are going to walk through some of the banking issues, and David and I may jump in here or there, and then we'll work our way into investing in the space and some of the things that you have to deal with that are unique. So with that, Brian.
Yeah, hi everyone, thank you. One thing I wanted to mention real quick, I did see a question in the comments about written materials, and I do believe we can make the PowerPoint presentation available. I thought that had been done, but we'll check into that. In any event, yes, so what we want to talk about next, I'm Brian Ellis with Bressler, and my friend and longtime friend and colleague Dan Rhoda of Abaca, who provides banking, finance, payment solutions to cannabis and cannabis ancillary businesses. So what I wanted to do first was just walk through a couple of the laws and rules that really establish the structure for which, you know, businesses can receive banking or financial related services. There's going to be some overlap with what Jess mentioned, particularly just with the Controlled Substances Act. Cannabis under the federal laws, as everyone knows, is considered a Schedule I narcotic, a high potential for abuse, brings with it significant penalties, you know, and could bring significant penalties. And there is an imbalance, a disparity between the treatment of this substance under federal law and under state law. About 37 states or so, I think I have that number, have some form of decriminalization or legalization of some uses of cannabis. So that the Controlled Substances Act really is the starting point. But then you have, you know, really under the Obama administration and James Cole as the Attorney General, there started to become a change of thought in enforcement priorities. And in 2013, the first Cole memorandum laid out a number of enforcement priorities and essentially said that the Department of Justice will federally prosecute only with respect to certain activities that threaten these priorities. I'm going to mention these 8 really quick, and then Dan, if you want to comment on one or any of them and just how they relate, you know, at this point to the basis for your business and how you're able to relate to your clients. So just for what it's worth, the 8 priorities, and we'll mention these again later, preventing the distribution of marijuana to minors, preventing revenue from sale of marijuana going to criminal-related enterprises or cartels, preventing the diversion of marijuana from states where it is legal to states where it is illegal, preventing state-authorized, so if the state permits marijuana for a certain reason, you can't use that as cover for another reason. So if you have a medicinal state, can't sell for, you know, adult use, recreational. Preventing drugged driving, folks getting behind the wheel, that's a real concern both on state and federal levels. The 7th is growing marijuana on federally protected lands. The federal government does not want public lands to be used to cultivate or grow marijuana. And the same goes with possessing on federal property, so growing or possessing. Those are the priorities under the federal government, and under 2013 Cole memo laid those out. In 2014, James Cole put out another memorandum essentially saying that banking services should be subject to those same priorities. Dan, let's talk about those priorities, and then we can talk about sort of the current state of things under the Trump administration.
Sure. So, you know, we refer to this, to the Cole memo and to these specific enforcement priorities that were laid out in the Cole memo. You'll sometimes hear me refer to it as the Magna Carta of the cannabis industry, or you will sometimes hear me refer to it as the list of very bad things, as in if you're a financial institution that wants to provide services to a cannabis business, you need a high degree of confidence at the financial institution level that your cannabis business customer is not doing any of these very bad things. And all of them are bad, but there are a few that we focus on a bit more closely, and those would be the ones that have to do with money laundering and with criminal activity. We're looking for signs of diversion of product, something as simple as selling product out the back door, and we are looking for any indicator that the cannabis business is actually being used as a pretext for other money laundering, which is something that is very common in any cash-intensive industry. And so for financial institutions, these anti-money laundering concerns are, of course, something that would apply to any business that they are banking or servicing at that institution. But when it comes to the cannabis industry, the the burden is that much greater on the institution to have this high degree of confidence that none of these things are going on. The guidance goes on to say that the financial institution needs to develop an understanding of the normal and expected activity levels of the business. And this is a bit of a term of art. The guidance, if you print it out, it's only like 3 pages, but it's really pretty rich in information and rich in direction there for financial institutions. This one sentence commanding financial institutions to develop an understanding of the normal and expected activity levels of a cannabis business at its institution, that in and of itself has given birth to really an entire industry of transaction monitoring to give that level of validation of financial institutions, with businesses like mine and several others that are providing that service, among others, to financial institutions that want to serve the cannabis space. The guidance also commands those institutions to monitor not just for those indicators of money laundering, but in fact for indicators of any suspicious activity, including but not limited to those red flags that you just went through. The interesting thing right now, which is I think where you're going next based on the next bullet point, is that the Cole Memo itself is in fact no longer in effect, right? When Jeff Sessions became the U.S. Attorney General, he very loudly and very prominently, shortly after taking office, rescinded the prior Cole Memos and said that he was walking back the federal government's hands-off policy here. This, to me and to several, really to anybody in the cannabis industry at the time, was kind of a moment where we needed to, step back and take stock and see what was going to happen. It was certainly cause for concern. The interesting thing is now here we are 2.5 years later, and in fact Sessions is no longer the Attorney General, but subsequent Attorney Generals have really followed the same path as well, and that is that the hands have continued to stay off. And so even though the Cole Memo is no longer in effect, we have not seen any major prosecutions. And the real interesting thing is that these enforcement priorities, the red flags, the list of very bad things, they remain in effect. Even though the Cole Memo is gone, these enforcement priorities remain in effect through the FinCEN guidance and are therefore then policed by the financial institution. And
prescient as always, that's exactly the next, when we're trying to think about what is the main enforcement network, what are the eyes that are watching the banking and the payment, and soon we'll talk about the investment community. FinCEN, to me, if you talk about the Cole Memo as the Magna Carta, this is really the watchdog. These are the rules to live by. And I guess the question I was going to ask you, Dan, is with Sessions rescinding the Cole Memos, but FinCEN essentially referring to those same priorities in overseeing financial transactions and ensuring that there's no criminal enterprise involved. What are your thoughts on those 8 priorities having some sort of precedential value or some sort of being beyond the memo, something that now companies have looked at, relied on, created policies and procedures in order to continue servicing this new industry, basically hanging on a thread by the Department of Justice, who could tomorrow turn around and say they're going to change it?
Yeah, so there are a few things there that I want to address. One is that there is this little-known budget rider called the Rohrabacher Amendment, and this is named after the congressman who originally got this tacked onto a budget several years ago. And what this basically says is that the Department of Justice is not earmarked any funding for prosecuting against any state legal marijuana business that is operating in compliance with the Cole Memo. And so even though the Cole Memo is not in effect, the enforcement priorities are brought into law, or at least policy, by virtue of the continued renewal of the Rohrabacher Amendment. The other interesting thing here is that after Jeff Sessions very, very publicly retracted the Cole memo, Steve Mnuchin, the Secretary of the Treasury, was asked in an interview if he had any intention of retracting the FinCEN guidance for financial institutions serving cannabis businesses. And what he said, and to this date has been correct, is no. He has no intention of retracting that guidance. They don't want to see all of that cannabis money back out on the streets. And so what we've ended up here with is a situation where the financial institutions are ultimately the front lines of fighting this battle and of enforcement, making sure these things are not happening. And so for a cannabis business, it's as simple as you either need to comply and need to structure your business so as to go take great lengths and make sure that you can demonstrate your people are not doing any of these things, or else you have to operate entirely in cash, which is expensive and is dangerous, and in some cases has resulted in kidnapping or worse. And so, you know, it's kind of an interesting situation, but the reality on the ground today for a cannabis business is you either need to be very, very proactive in your compliance here and in demonstrating your compliance, or you're simply not going to be able to put your money in the bank.
Exactly.
And ironically, Dan, going to your point about operating in cash and having all the AML issues, the irony of this entire dichotomy to me is the fact that the goal here is anti-money laundering, and by putting everything in cash, you're essentially making the job more difficult of the financial institutions and the government to make sure that there is no money laundering. It's easier to have access to the financial institutions and to give control and to have the controls and to have monitors to make sure that, you know, everybody's watching the store, so to speak. Here, the way that it's set up, it just makes all of the regulators and makes all of the AML officers at the financial institutions' jobs that much harder. Wouldn't you say?
Well, yes, and sorry, hearing some echo there. As a result, what you end up with is a situation, and this is common across many aspects of operating in the cannabis industry. How shall I say this? On a very basic level, it simply costs more to obtain banking services for a cannabis business than for any other business. This burden has been put on the banks, and the cost of complying with this burden is obviously going to get passed on to the customer. That's simple economics right there. And so for a cannabis business owner or an aspiring cannabis business owner or investor, they just need to be aware that banking is just one of those areas where you can expect to pay more for these services than you would pay if you were in any other industry.
I think that's a good segue into the, so just to put a final touch on the FinCEN, essentially comply with your anti-money laundering rules, the Bank Secrecy Act, and certainly the filing of suspicious activity reports where necessary. Safe banking. So Congress last September, the House of Representatives passed the Safe Banking Act, which, I guess the current status of that is as it's been. It hasn't had any traction in the Senate. Trump really hasn't come down one way or the other. And while the Safe Banking Act provisions were included in a draft of the next COVID-19 relief package from the House, kind of forcing the Senate to address it or reject it, at least make some sort of comment. We still are in a state where how do banks get comfort working with cannabis companies? I guess that's the question going forward. And not just banks, but payment processors, folks who can facilitate the transactions.
So it's a function of risk management. If you look at the filing data, since there is this very, very robust SAR filing requirement, you will see, and FinCEN reports on this quarterly, as many as 700 different financial institutions, which is roughly 5% of the chartered banks and credit unions in the country, have reported having some dealing with the cannabis industry. by virtue of those SAR filings. And it's one of these things that fluctuates over time. We've actually seen it kind of taper off there, but this number 5% is really very, very small, and it's in fact probably fictitiously large, because you've got the banks in there that are filing suspicious activity reports because they are serving cannabis businesses in the ordinary course of operations. You've also got banks that don't serve the cannabis industry but have discovered a cannabis business and have followed through with the required procedure to terminate that account and file that SAR. So the two get jumbled together and the data gets confusing. The conventional wisdom among those of us who work actively in this space is that there are 100 or fewer chartered financial institutions in the country today that are truly openly banking cannabis transparently. And for those financial institutions, they are taking a risk in very much the same way that an individual who gets a state license to grow or dispense cannabis is also taking a risk, in that you are violating federal law. But there is, of course, a profit motive for doing so. For banks, this can be a very, very smart thing to get into this space. It's a rapidly growing industry, and you've got customers who are getting turned down by other financial institutions. So it's a great opportunity to earn some long-term goodwill and, grow your financial institution, but you are taking a legal risk, and you need to go to great lengths to mitigate that risk every way you can. And so just like an individual who gets a dispensary license needs to go to great lengths to operate that business by the book and demonstrate that they're operating it by the book, so that they can hopefully avoid any sort of criminal prosecution or other negative consequence, a financial institution that is serving this industry needs to very much do the same. Go to great lengths to ensure they're complying with this guidance, and that they can demonstrate to the regulators that they are in fact in compliance with the guidance at all times. And so there are really two ways financial institutions go about doing this. You can either hire a whole bunch of compliance officers, kind of the analog way, or there are some specialty technology firms out there like ours that can help digitize some of these workflows and the monitoring and other things that are required. But at the end of the day, it takes a high degree of due diligence and confidence that these customers that your financial institution is serving are the good ones, that they are operating their businesses by the book and transparently.
Excellent. And again, we're talking about financial institutions, but it really is a limited number of types of financial institutions. I think one of the areas, that broker dealers don't have the same type of considerations laid out in the Safe Banking Act provisions, and it's really a different type of set of challenges for other types of financial institutions. So, I guess going forward, where do things stand? So, New Jersey, we have a ballot initiative in November. I know that there is progress being made in other states. I guess what would be, if we're trying to think of how to structure a legal industry, what are the biggest challenges facing banks and I guess other financial institutions in working with states? And Nick raised an excellent point. The biggest challenge is anti-money laundering, but it's all cash, and it's cash because there's no other mechanism in place. So what are your thoughts going forward? You look at the rest of 2020 and the next couple years. Where would you like to see the industry, and what do you think are the easiest ways to get there? And I think maybe this is a good time to bring Dave and Nick in to talk about capital markets, to talk about growing the industry and the different types of transactions that are out there.
Yeah, well, if you're asking Dan's personal opinion here before we move on to everybody else, I personally feel that, the Safe Banking Act, if it passed, would be a great sign of progress for the industry and would absolutely be something we would celebrate. It's what we'd call a half measure. It does not go all the way. In a world where the Safe Banking Act has passed, but that is really all that we have passed in terms of any sort of cannabis, decriminalization or any other activity at the federal level, what we're left with is a world where cannabis is still illegal to manufacture, distribute, transact for, but it becomes legal for financial institutions to take the proceeds of those transactions under limited circumstances as prescribed by the Safe Banking Act. So you will continue to have a very, very high compliance environment for operators on the deposit banking side. And then on the payment side, which you touched on, you're unfortunately not going to solve the problem, I believe, of getting Visa, MasterCard, Discover, and Amex, the 4 major card brands, into the cannabis game. That's not to say that you couldn't walk into a dispensary in Colorado or California today and swipe a credit card, but there are some workarounds people are using. Generally speaking, we don't endorse most of them. As I would advise a customer, they might think it's harmless to, say, fill out a merchant application claiming that they are a bakery, and they obtain a credit card processing terminal there, and it works until they figure out what you're doing and shut it off, and it doesn't work. That seems there's a conventional wisdom that that's like a victimless crime or something, but I would posit to those people that what you're in fact doing there is misrepresenting a material fact about your business to a financial institution in order to induce that institution to provide a financial service. And so, the other word for that is fraud. Yeah. So it's not something we recommend, and you don't need to necessarily believe just my opinion on that. There are a couple of interesting pieces of litigation on this point that should be checked out. One pertains to Ease, the popular cannabis delivery app on the West Coast, where they were in this lawsuit accused of misrepresenting various things in order to obtain credit card processing. The suit has been settled, but I have now recently found out that one or more of the principals of that company are apparently the target of a criminal investigation regarding those same facts. And so that's certainly not a position anybody wants to find themselves in, especially for doing something they thought was harmless and victimless. And anybody who's interested should also look at the ongoing litigation involving Lynx Card, Linx, and First Data Merchant Services. That's in your neck of the woods in the Southern District of New York there. This is, again, an interesting case where a payments provider perhaps misrepresented the true nature of the payment that was being processed, and it worked for a while until somebody at the credit card brand level discovered what was going on and pulled the plug. And when they did, it resulted in a chain reaction that has resulted in a couple of prominent Las Vegas dispensaries not receiving their merchant settlements for several days. There's been about $500,000 pled into the registry of the court in the Southern District there, but according to the pleadings that are filed, there's another $500,000 or more that nobody knows where it is. And so that's another interesting one, definitely worth following. Remains to be seen what the potential consequences are. But again, if safe banking passes and cannabis is still illegal at the federal level, I don't believe that's going to be enough to get the major card brands into the game. And so as a result, you're going to see the status quo continue where these workarounds are the name of the game. And that's not a complete solution, in my opinion, and I'd be real curious to hear what David and Nick think the impacts of that, of safe banking's passage, would be on the capital market side of things as well.
And going to your point, I think that the key here is really deschedulization under the CSA. The CSA is the main problem. When you're a Schedule I narcotic, no one's going to want to, no financial institution, no large financial institution is going to want to be really involved 100%. They'll do the bare minimum that they can, but until there's a resolution there, there's going to still be issues. Mm-hmm. I always find it ironic to see that cannabis marijuana is listed as Schedule I. I know hemp's has been lowered, but heroin's a Schedule II, which I always find that to be slightly backwards. I'll just say.
Yeah, cocaine as well.
Yeah, cocaine. Well, cocaine was a very highly used pharmaceutical in the early 1900s.
Sure, it's a vasoconstrictor vasoconstrictor and I guess a topical anesthetic, among other things. But
Yeah.
you know, as we know, there are also a number of potential medical and therapeutic uses for cannabis. So to see it at an even less favored state, you're right, it's certainly ironic.
Yeah, yeah. So thanks, Dan. That was very helpful. And if you want to jump in at any point with feel free here. So we just wanted to, as we're winding down, we wanted to talk about some of the capital market considerations, and obviously access to capital, as we've touched on, is difficult. But we wanted to talk. I'm going to actually jump to the next one. It's all good. So I wanted to talk about how publicly trade, because we've talked about how difficult it is for cannabis companies to obtain banking services and participate in the financial system, I'll just say. But the reality is we see numerous companies that are listed on various stock exchanges, and the way it's ironic to me that you see Canadian companies listed on the New York Stock Exchange, and some have dual listings, and some are listed on the Toronto Stock Exchange as well. But you have U.S. companies listed in Canada. So you have multi-state operators in the United States, and they are publicly traded in Canada, but they can't be publicly traded in the U.S. There are some that operate on that do trade on the OTC bulletin board, but not on the New York Stock Exchange. So, Dave, if you're we've touched on how difficult it is for financing the cannabis companies, and they have to look for alternative financing. And obviously, Yorkville provides alternative financing solutions for public companies predominantly. If you're looking into a cannabis company, what are some of the considerations that are unique to the cannabis industry that you take into account when looking at a potential deal?
Well, I mean, just to kind of back up a little bit, just because we're an alternative, financing route doesn't mean that I'm going to act any less different than a bank or a cannabis company who's looking to find a banking institution. So, we have all the same considerations that, banks have, right? I'm going to do, very strict and stringent AML, KYC procedures, on actual management, board directors, any subsidiaries they have. And then we're going to, build in a very robust, set of compliance with law provisions, various, warrants, covenants, representations, that the company's operating within the bounds of the law. That if any point in time they do trip up any of these, warranties and covenants and reps, it's going to give me various remedies, right? And as aggressive as being able to rescind the investment. So, although we're an alternative route, I'm probably not going to be much easier, for a cannabis company to get an investment from. And the reason that we have to do that is because, one, for the protection of our own investors, but also for the simple fact that we have various counterparties that we're going to interact with, who are going to know we are invested in some of these companies. So it could be, the banks that we're using in order to wire funds out to, or it could be brokerage firms who are selling the equity. So I need to be able to represent to those like counterparties that we're also not, running afoul of the law, right? And that we're, actually compliant with, all federal requirements of making these investments. So, in terms of the investments in a cannabis company, I'm probably going to take, a harder look at making sure that AML and KYC procedures are tight, that we're satisfied with the due diligence, make sure there's no bad actors there, make sure that my, like OFAC screenings come back, clean, that there's no doubt, I really can't leave any stone left unturned, because at the end of the day, for us, it'll have like ramifications that go up and down our like organization, from issues with our underlying investors who we have a fiduciary duty to impacting relationships with counterparties we have. And like I said earlier, those counterparties notably are banks and brokerage institutions. So, it definitely is a stringent process. And although we're an alternative route, we're not going to be any faster in order for one of these companies to obtain an investment from, than if they were to go to one of the traditional, larger investment banking institutions.
Right. And when you do look at a deal, what are some of the protections that you're going to want, since it is obviously a risky business still, regardless of the fact that it's a $20 billion industry, and I've been reading more. What are some of the things that you want to protect to protect your investment if you're going to do a deal with a cannabis company, with a multi-state operator, or whomever? What are some of the things that you're going to look to do to protect your investors, and the company?
I mean, in addition to really beefing up my reps and warranties and my covenants, again, the ones that I had mentioned earlier, the compliance with law sections. I will add my FinCEN stuff in there, in order to make sure that, the companies are representing and warranting to us that they are in compliance, with all of the FinCEN mandates, and covenants that they'll continue to do so during the length of my investment. We'll also look to secure the investment with, other means. So what I mean by that is, maybe we will take pledges of collateral, right? That collateral can take the form of maybe real estate that these companies own. Licenses are hard to secure because, a lot of the states that do grant licenses do not allow licenses to be posted as security. So we'll look then to take, a coverage in the shares of the company's common stock. So what I mean by that is, if I'm making $1 million investment and based on what my purchase price, I'm entitled to 1 million shares of that like company's common stock, I may build into that agreement that I'm going to get a multiple of the number of shares that I would be entitled to at my purchase price, that then I'm entitled to, for lack of a better word, a penalty number of shares in the event that any of these reps and warranties get tripped or any of these covenants get tripped. I could look to take a pledge in companies, in shares that the company holds of maybe other companies, maybe another publicly traded company. It's a very incestuous business, so a lot of these companies are doing business together and seeking investments from one another, or like operating businesses that are complementary to theirs. So maybe it's like an extraction company, and they're getting some of the edible products that they sell from like another public company, and in turn, because of that arrangement, maybe the company that I'm investing in holds shares of that other public company. So I'm going to look to take a pledge of actually those shares, or look to take a pledge of management, of actual management's shares. So it's really bells and whistles, suspender type stuff. So in the event that, God forbid, there is a trip of a covenant or a rep and warranty and something that's not going to be an easy fix, I at least have remedies that I can access quickly in order to save my investment, or at least make sure that my investment has some movement and I'm not sitting there and waiting for one of these reps and warranties to get remedied.
Right. And as we were talking about with Dan, everything is just a little bit more expensive, right? I mean, you have to pay more attorneys, you have to deal with more compliance folks, you have to do more due diligence. Everything within the industry, it's a more labor intensive, I'll just say, endeavor, right?
Yeah. Unfortunately, the cost of capital when you come to an alternative investment form is going to be a little more expensive than normal, but now add on the risk of maybe a cannabis company where it's going to be a little bit more expensive because I do have to deal with all the AML, KYC like considerations. My like documents, will be a little stouter in terms of reps and warranties. So it's going to take me a little more time to actually draft those agreements. I can't just go in and pull out like boilerplate documents and just kind of change names and things like that. So they are a little more, a little more legal intensive. My compliance, guys will have to monitor these investments a little more. So it just, we have to put a little more time and actual resources into it, which will take away from some of the other investments that we might be looking at because maybe they're like a little easier to do. So as like a result of that, the cost of capital is probably going to be a little higher.
Great. Okay, and I think was there anything else that you wanted to touch on, Dave, or was
no? No, I mean, other than the fact that we think it's still a very viable space. We think it's still a very exciting space. We're always interested in looking at investments there. Notwithstanding the fact that you have to watch them a little more, and they take a little more time to kind of go through and do the due diligence and actually document. We still think it's a very exciting space.
And you'd like companies that come to you with all of their trademarks in order, with their banking relationships, everything that we've talked about leading up to today. If you listen to Jessica and Dan and Brian working your way through, makes your life a little bit easier, no?
Yeah, it does. It does make our life a little bit easier for sure.
So, all right. Well, the second CLE code is going to be THC. I think people probably figured that one out. And just wanted to thank everybody for joining us. Our next presentation is going to be in 2 weeks. No, that's the wrong date. Oops, sorry. I'll just, I believe it's 2 weeks. I'm not 100% certain because I think we need to update that slide. But Brian, did you recall what it was?
I think July 29th. But let me
July 20th. Is that the correct next one? Backstage All Access Pass, preparing, presenting, and winning your virtual case? I think so. Well, if not, it will be a surprise, but I believe it's going to be a virtual case update and how to prepare for that in this ever-changing world. Thanks, everybody, for joining us. And if you have any questions that we didn't get to, feel free to reach out to us. We will be circulating the materials via email. And just wanted to thank everybody for joining in.
Thanks, guys.
Thank you very much.
Everybody have a good day.
Thanks, everyone.
Take care.
Exit.